first, Your Honor. Thank you.
Good morning,
Good morning.
Mr. Gorman.
May it please the Court, I'm here on behalf of the appellant Rosalie Virusso, also known as Rosalie Abbott.
What do we do about what I understand is the change in circumstances? She's out in Arizona, isn't she?
She is, Your Honor, and I can address those issues.
The boy, I think it's a boy, an issue is over with the father?
He is
in Newton?
Well, it appears that now he's not in Newton. It appears, based on changed circumstances, that he's in fact in a different town in Rentham. And Mr. Virusso has remarried,
Right.
moved to Rentham. The Newton school systems, from what I understand, have now requested that Mr. Virusso has met with the school systems, as I understand it, and Jared has been requested to leave the Newton school systems by December 21st of this year.
And go to the Rentham.
Correct.
He's living with his father, though, is it?
Correct.
So
And
my point is...
He's living with his father because his mother was precluded from taking him out of state. Is that
That's right.
correct?
And that's right. And one of the things that the appeals court, I think, properly concluded, in addition to vacating the judgment, was remanding the case to the probate court so that the court could consider, the way it's put in the appeals court decision was within the discretion of the probate court, they could consider changed circumstances. I'm confident that the court would consider those changed circumstances. I think, I objected to inclusion of matters in the record that weren't part of the record appendix, and I don't think this court wants to hear all the back and forth of what's happened since the trial. On the other hand, I do think...
How old is the boy now? Is
14.
He 14 now.
He was born on October 23rd, 1989, and
Okay,
I believe he's in the 8th grade, so he would be moving on to a new high school.
And is Haley now in college?
She is. She's at the University of Vermont. So one of the issues that the court was concerned about, and Rosalie was concerned about, and I think all the parties were concerned about, was the level of contact and communication and involvement that Haley would have with Jared.
Well, one of the difficulties is sometimes when you get siblings that are older than younger, as you say, they're sort of marked places. We've had a number of cases where, for example, one sibling is, let's say, a junior in high school and doesn't want to move out of state because he or she has spent, all of their years and they want to stay and graduate. Whereas the younger child hasn't yet started. To some extent, I think what trial judges and parents try to do is to figure out, yes, sibling contact is terribly important, and there may be different children who are at different stages of their education where it may make sense for one child to stay rather than putting sibling contact as the highest, although that's important value. And it struck me that might have been one of the things that was happening here. That's number one. And number two, the older a child is, we tend to be deferential to that child as to with which parent does the child want to remain, and that is often informed by what does the child think of the existing circumstances.
That's right. And those are fluid.
But my point is, 4 years or so have elapsed. How can we really decide this case? I mean, if we agree with Judge Kantrowitz, the dissent, that's the end of that. If we agree with your position that, there ought to have been this thing was done wrongly, it's all changed since.
I don't think there's...
So
Well,
what do
we would have
do?
to remand. We
That's
would
right.
vacate, remand to the probate. This judge is now retired. Remand to the probate court to either rely on this judge's findings or, because of the change of circumstances, take new findings, take evidence and make new findings and make a new decision. Is that your position?
Yes, I think there's some judicial economy, frankly, in having the case remanded, because there's been a record created that includes, this case didn't rise out of a vacuum. The record includes investigative evaluations and reports by the guardian ad litem during the process of the party's divorce, which concluded in 2003, and which was a hotly contested divorce, I think is how Judge Rockett referred to it. There was then the subsequent evaluation by David Goldman, who participated in the complaint for modification and for the removal, so that the benefit of having a record on remand and picking up with the changed circumstances, I think, is...
Well, that's what you've asked for.
That's right, and that's what the appeals court directed. I think initially our request was that the case be...
How does the guardian ad litem or the investigator, whoever it was who testified, get to make statements about legal conclusions?
Well, David Goldman is an attorney, and I know that I believe he was involved in the Annis case as either an attorney or an investigator or evaluator. To the extent that he had familiarity with the removal standards, I think he considered those standards in assessing the reasonableness of the move. So I don't think that he was viewing himself as a judge so much as just being cognizant of what the standards were and applying those standards to the facts as he investigated and evaluated. The involvement that he had has been criticized, but I think it's fair to say that he interviewed virtually all of the relevant parties, that he did review and evaluate the prior reports, and that based on his experience in cases, I think he testified that he had this role in many other cases, he reached the conclusion that we think the proper conclusion that Ms. Abbott had satisfied the real advantage.
And the judge was not required to accept that, and we've said that in other cases.
No, I agree, Your Honor. And
Mason
I think
versus Coleman, the judge wasn't required to adopt the opinions of the GAL, the therapist, the psychologist, the school official, other evaluators.
That's correct, Your Honor. But I do think that, number one, there are limits that an appellate court gives in terms of deference to custodial determinations. And number two, I think the appeals court correctly concluded that the lower court had given insufficient consideration of the quality of life of Rosalie Abbott. And my own view is the real advantage standard, as this court has directed, is a lens through which you determine the best interests of the child. The best interest of the child is a critical inquiry, but the real advantage standard provides a mechanism to reach that endpoint. And
It's a threshold
correct.
determination.
And the problem in this case is, I think, and I think the appeals court agreed that the judge was influenced by his criticism, his disagreement with the real advantage standard insofar as he said it's discriminatory against the non-custodial spouse.
Yes, I mean, essentially it seemed to me that what the trial judge was trying to do was to relight our Yanis case.
Right, I think he was
in the sense that
recalibrating it.
the tragedy here is sometimes it's joint custody, but sometimes it can be joint custody with physical custody. I mean, basically, as is often the case when there are separate households, is that one parent becomes the primary custodial parent, and that's just one fact. And the other factor is that we live in a very mobile society. And even people who remain married often have to, do long commutes and so on.
I think the appeals court touched on that in a footnote where it referred to some variation in how terms are used with regard to shared custody and the like. And one of the reasons why we believe the Mason court does not control those cases because the visitation arrangements were fairly traditional. Every other weekend, essentially, I think it was
well,
first.
In the divorce,
yeah.
It was called shared physical custody according to the following schedule.
Exactly, and that was.
So you're saying it's shared physical custody, but not really shared physical custody.
What I'm saying is that there's a primary custodial parent, and that was and had historically been Rosalie Abbott. And in that regard, I refer to the findings of the guardian ad litem in the divorce court, and as to which there was no testimony or evidence that those findings were no longer valid. What the guardian ad litem found and the divorce court adopted was the notion that the principal caretaking functions for the children, including Haley, by the way, up until the time of the divorce, were performed by Rosalie Abbott.
Yeah, and the guardian also found that Jared didn't want to leave, didn't he?
He did, and he based that on the fact that Jared had expressed a preference to stay in Newton.
Now, Jared was 11 years old at that
Correct,
time?
he was 11
and
years
now
old.
he's 14.
He is.
And so if we were to remand, they'd have to do some current update to find out what his current thinking is.
That's right, and in that regard, I think the appeals court anticipated that in the event that the trial court considered an interview would be appropriate, that the mechanism or the protection of a recorded interview would be appropriate. We had objected at trial on the grounds that we thought that perhaps the guardian ad litem should participate in that, but I think a recording or some other protective measures that could be implemented and should be implemented so that the parties would have, the opportunity to review and safeguards built into that function.
Did
But I
the
think
I
parties-
have
I'm
two
sorry,
other
go ahead.
two other questions for you. What grade is Jared in right now?
8th grade.
Okay, and the trial judge concluded that the Newton schools were better than the Arizona schools, but now you're telling us that Jared will be attending Rentham school system.
Well, all I know is that that's what the Newton court has, and based on nothing in the record, but is that the Newton court has requested that he cease attending Newton. He's been commuting, as I understand it, from Rentham to Newton, which isn't a...
Was there evidence that the Newton schools are better than the Tucson schools?
Well, I think the judge, I think the
Took
evidence...
judicial notice that the Newton
Took judicial
schools are
notice to
nationally known as one of the better school systems.
There was some
Kurt
statistical...
Schilling backs him up.
Well, there was some
No, this is
statistical...
true. I mean,
Yeah.
he was interviewed, and he didn't want to be traded because his wife says the kids fell a year behind in Arizona when
Yeah.
they were there once they came back from Massachusetts.
I don't know if he's
Is there
had
an
the
affidavit in this case?
Well, that
from Mr.
settles
Shaw?
that.
I haven't
Right.
seen it.
I don't know if
We're
he's
gonna
had the
take judicial
opportunity to
notice?
assess the
It's sort of
rental
generally known that the Arizona
Maybe I
schools may
should
not be
hold-
as good as the Massachusetts schools
Maybe
in
I should
certain
not
districts.
comment because I have granddaughters in the Newton schools, but...
Does
so
anyone
I'm not
have any
gonna-
relatives in Tucson?
Do the parents here have joint legal custody?
They do, yes, with respect to Jared. And with respect to the school systems, I think there was some statistical information that Rosalie Abbott had provided at trial. She had done an investigation. Jared had actually visited the schools while he was out in Arizona. His reaction, according to her testimony, was that he seemed excited about
Well,
it.
as Justice Duffley said, that neither party maintains that the case is governed by Mason against Coleman, where we had joint physical and legal. I mean, so...
Right.
I don't know what
Yeah,
the parties...
well, Judge Kantrowitz, though, thought that Mason did control, or
Well,
should
I
control.
think he made a comment on it, to the effect that maybe it was in some ways closer, but I don't think he identified or focused on the principal caretaking functions that had historically been performed and were referenced in the evaluations, an extensive evaluation by the guardian ad litems in both the divorce case and the removal case. So that his assessment that the
In any
Mason court,
case-
I think, was purely on the reference to shared custody, which I think has so many variations to it. That it
What,
doesn't
in your
really-
opinion, did the judge do wrong? I mean, he recognized the primary consideration is real advantage to the mother. He addressed that, at least according to Judge Kantrowitz, that her opportunities for a different kind of job in compounding pharmacists, whatever you want to call it, in Arizona were, really not there. Then the best interest of the children, of the child, he went exhaustively through that, the school system, his preference, everything else. What is wrong with that?
Well, fundamentally, there are a couple of things wrong. One is that and the appeals court identified that he did not give continued consideration to the quality of life of the primary custodial parent, and that
Well,
colored
he said,
his
one of
findings.
his bases is that he disagrees with Yanis, because he thinks that Yanis doesn't focus on the best interests of the child.
Right, and I think the overwhelming
He'd be
precedent
right on
is...
that.
Well, the overwhelming precedent is that the interests of the child are interwoven with those of the custodial parent, and that's why the significance of the real advantage standard in the type of case that this is so important, because you have to have that mindset or that ability to look through the lens of the real advantage to the mother as, in this case, the mother as the primary custodial parent for Jared, in order to determine whether is his quality of life likewise going to be improved. And I think the judge discounted or didn't give sufficient weight to those social factors, those emotional factors that, in our view, established a real advantage to the proposed relocation.
Could I ask you one other question about mother? At least when the appeals court opinion was written, it was unclear about whether she'd be more likely to find employment out in Tucson, and whether her business would be able to function better out there than here.
At the time of trial, Your Honor, and I think that the probate judge did discount the economic significance or professional significance of the move. At the time of trial, she was licensed to practice compounding pharmacy in Arizona, had 2 job offers. The judge did find that there would be an economic benefit from the availability of James Cedars' contribution to the household finances. As far as the current situation is concerned, she is employed as a compound pharmacist, and I think that her expectations are being fulfilled in that regard. At the time of trial, we had to acknowledge that she did not have a job, but I would submit that that's going to be the case in any number of situations where a spouse is planning to move or a former spouse is planning to move. And
You haven't moved, one hasn't moved yet.
yeah, the difficulty is you can't accept a job unless you have that opportunity that most people don't have to worry about, frankly. So that in terms of the economics, we think that it was proven at trial. We think that it would be proven on a remand that the circumstances are more beneficial even than we would have thought at the time of trial.
Is Cocapelli going there?
Procopelli or variation of it, yes. In other words, the opportunity to be involved in marketing the nutraceuticals that was the principal basis for the Cocapelli.
Whatever that word is, what are they?
Nothing that I take, Your Honor. I think it's in some fashion maybe less traditional pharmaceutical
Holistic
health.
stuff?
It's like a health. It's like a health.
I think that's right.
Store where you would get, herbs and stuff, and
I think that's
different
right.
kinds of things like that. I mean, it's recognized as being very beneficial in a lot of circumstances.
And I think the judge was skeptical of the notion that Tucson would be a more receptive environment to that. But having lived in Massachusetts all my life, I think that he may have been wrong about that.
Thank you, Mr. Gorman.
Thank you.
Ms. Minchoff?
Good morning, Your Honors. May it please the Court, my name is India Minchoff, and I represent Michael Virusso. I'd like to start...
I have, before you start, I'm sorry, but I see at least three errors in the judge's decision, and I'd like you to comment on them. The first is that he says the standard of proof or sole focus in removal cases should be the best interest of the child, as opposed to whether or not the move would benefit the custodial parent. Now, isn't that a false premise, number one? That's my first question, because the real advantage is a consideration, though not the controlling consideration. It's at least a threshold inquiry. And then he says the present law of real advantage on removal cases favors the custodial parent. Where does he get that from? Because he moves from this false premise to saying that the real advantage test to moving is he makes this error about it being discriminatory. And then he also, with his findings that the move would benefit the mother financially, socially, and emotionally, he makes all those findings, and that the mother wasn't moving in order to deprive the father of visitation. Then he makes the conclusion that the mother hasn't made out a case to sustain the move. She hasn't sustained her burden. So I wonder how you rebut those three problems that I see in the judge's decision.
Absolutely, Your Honor, and I'll take them one by one. And I do think they all have a common thread, which is that the benefit or the real advantage to the mother does not automatically translate to the best interest of the child.
Of course it doesn't.
I'm
not
Of course it
suggesting
doesn't.
that.
And I think that when
I'm just saying it's the first part of the test.
I think that the trial judge definitely expresses disfavor with the Janus standard in that since Janus, it has evolved in application to, in essence, looking at many appeals court cases, the fact that they're being remanded and essentially asked to look at the custodial parent's interest more, that they touch upon it in their decisions, in their findings of fact on the trial level, and that the appeals court has essentially heightened the level of the custodial parent's benefit in their decisions.
The appeals court is following Janov.
Well, Your Honor, I would state that since Janus...
I think that the trial judge was clearly indicating that he thought, I mean, his first question is that Janov contains, quote, inherent discrimination. I would say this is a trial judge who was uncomfortable with the ruling of the highest court.
Well, I believe that the trial judge also made it very clear that he followed Janus in this case. So I would state to this court that he has stated in his decision that he has adopted Janus in deciding the facts of this case. I think that his findings of fact clearly established that he took into account the benefit to the custodial parent. Now, he found against her in certain aspects which she tried to prove, one being that it would be an economic or employment advantage, and that was a finding of fact.
It seems to me, Ms. Minchoff, if you go to Justice Cowen's third point, that essentially he lists fact findings about the real interest test, and then that's sort of put aside, and then he just goes to the best interest. He doesn't try to mesh them in any respect.
Your Honor, I would state that I do believe he has tried to measure them. I mean, he has stated that one of the reasons that the mother has proposed this removal of her minor son in a split living situation to remove one child from Massachusetts to Arizona would be that she's going to have advanced employment opportunities. Based on all the evidence at trial, he made the finding that those employment opportunities did not exist for her. And those findings are factual findings which should not be overturned. He gave deference to her.
There was no suggestion in this trial that the mother wouldn't have the financial wherewithal to take care of her son, is there?
Well, one of her main purposes in moving that she had at the trial court, and the record supports this, was that
Her main purpose in moving is because she is married to a man, she's engaged to a man, I don't know what she was at the time, who's moving out of state, correct?
that's the underlying desire for her to move, and
Of
that is
course,
it.
yes.
She
I
subsequently
mean, it's not
tried to
because she
support that.
decided that on her own, unconnected to a fiancé, correct?
No, she didn't wake up one day and say, I want to move to Arizona because I think this is going to be the best interest of my child.
No, she didn't wake up one day and say, I want to move to Arizona because there are better employment opportunities there. What she said was, I want to move to Arizona because I am engaged to a man who is moving to Arizona, and I can financially take care of my child because there are employment opportunities that may be better in her mind, but she was saying, I can be employed there.
I don't disagree that that's probably the logic of how the removal in this case happened. I think that's very clear from the record. But taking that, what you just said, and looking at the real advantage standard, which is the threshold, the first, did she surpass that? Questionably whether a fiancé, where you're not showing that level of commitment, actually satisfies it. But I think the trial judge went ahead and gave it as a given in this case.
A fiancé, you don't satisfy it?
I said it's questionable whether it rises to the per se level of marriage, which you've satisfied the real
So
advantage
here we
threshold.
have a problem. Before an adult makes the serious commitment of marriage, not knowing whether she's going to be able to follow her spouse, it's not as serious if she has there's a fiancé. You're saying that you have to marry somebody first?
I'm saying that I'm not sure that it rises to the level of a per se sincere reason. I think that marriage does show a commitment when two people
I
are
think it
capable
may
of
show
doing
a
it.
great commitment to the well-being of your children.
I didn't hear the question.
It
I'm
is
sorry.
possible, would you at least entertain the possibility, Ms. Minshoff, that somebody sincerely wishes to move, is engaged to somebody who is moving, is not an attempt to deprive the other parent, but who is concerned that the court may decide that she cannot take or he cannot take a child or their children out of state. So before entering into marriage, wants to have that resolved, and you are now holding that against the person.
I don't think there's anything in denying a removal that would prevent a parent from being married. But more importantly,
Certainly. It may be that she doesn't want to leave her children. So she may not be able to follow, or he may not be able to follow somebody with whom she is deeply involved and intends to marry. People do choose their children over a spouse.
No, I understand that people do choose their children over a spouse. Your Honor, in this case, this woman did, I understand, move to Arizona with her fiancé, which has been pointed out. But I just want to get back to the kind of point in this case where I think that we can take for granted that the trial judge actually found that there was a real advantage to her in being with her fiancé. He states it in his findings that he does find that she will most likely be happier in following her fiancé to Arizona. Now, I may have a different opinion of whether fiancé satisfies that real advantage, but I don't think it needs to be addressed for today's purposes. With respect to that, he analyzed that, he found that. Then he moved to that second inquiry. So, yes, he has stated a disfavor for how Giannis has been applied, but he applied Giannis, and that is what's important. Essentially, his question was dicta in, has Giannis discriminated against a non-custodial parent and elevated the interest of the custodial parent? Now, I do believe in looking at many of the appeals court cases that have been the offspring of Giannis, that Giannis has evolved to almost that inquiry that the judge has made point of. And as a trial practitioner in the probate courts, this has become an issue amongst the trial bar as well as the trial attorney. So I do think the trial judge took note of this, and that's why he made a reservation in the report.
Ms. Minshoff, it seems to me that in both his decision and in Judge Kantrowitz's dissent, that a lot of emphasis is put on the relationship between the two children, and obviously moving to Arizona is going to interfere with that. That circumstance has totally changed in the sense that now we have one child in college, so they're not living in the same community. And so even if you take everything that Judge Rocket said, don't we have to deal with the fact that it's a very different set of circumstances that we're looking at and in doing this calculus of what's real advantage at this point?
And don't we have to add, because I was going to ask you the same question, but don't we have to add in that also the child is now no longer in the Newton schools, but is going to be in some other school system, we don't know what, but most likely a school system that's not as good as the Newton schools. So wouldn't that be another factor of changed circumstances since those that govern the judge's decision?
Actually, that's incorrect. He is still in the Newton school
Well,
system.
he's about to be out of them.
I know that Mr. Virusso still retains the residence in Newton, so I'm not sure that that information
Well,
is
that's
correct.
something that has to be, therefore indicating that something has to be, more has to be decided by the trial judge.
But the issue is whether the judge was wrong in what he did back then.
right.
Parties can always petition for reconsideration or a change of circumstances. So, I mean, it strikes me that the judge says very clearly here that he used the standard in Giannis, but distinguished the immediate case because of the split custody arrangements.
I agree, Your Honor, and I also would say that in looking at the findings of the court, this case is very similar to the Dickinson case, where you had one parent that wanted to move to California, and she didn't establish, although she would have been happier, she established a real advantage and wanted to follow her husband to a place that he wanted to be. She didn't establish that it would be in the best interest of her child. And ultimately, this is the crux. This is what Giannis says, that the best interest of the child is most paramount. And that's what the trial judge essentially just reiterated, that it should be the sole focus.
Well, all right. Okay, I guess you're just going to answer what I was going to ask you. We got a dispute here where Judge Dunphy, in her opinion, in so many words, said he didn't apply the Giannis standard. And Judge Cordy just suggested that he did.
Well, he says he did.
Says he did. Now, Dunphy says, and I'm quoting now, despite these findings, the trial judge concluded the Giannis standard did not focus sufficiently on the child's best interest, which he felt should be the sole focus. Now, we've heard questioning today that that isn't correct, that that's error. Do you agree that that's error?
I'm sorry, Judge Graney, I'm not sure I quite understood. Are you asking me if I disagree that it's error of the appeals court finding?
No,
Judge Dunphy said the trial judge, this is the appeals court majority, concluded that the Giannis standard did not focus sufficiently on the child's best interest, which he felt should be the sole focus. Is that right?
I
If so,
think
then perhaps he's in error, the trial judge.
No, I think he made in
Or is this
dicta.
some gloss that the majority of the appeals court have put on his decision to get,
His decision was not premised on the fact that Giannis was wrong. He made it very clear that his decision in this case, based on this facts and the circumstances that existed, was based on the real advantage standard.
If we look closely at his decision, and if it appears to apply Giannis, then as far as you're concerned, that's probably the end of the ball game, because they have, as Judge Kantrowitz points out, a huge amount of discretion in this area. Am I right?
That is correct. That is correct. And
I don't see how we can respectfully look at his decision and say that he applied Giannis when he says the standard of proof or the sole focus in removal cases should be the best interest of the child, as opposed to whether or not the move would benefit the custodial parent.
What do you say to that?
I say again to that is a statement made in dicta, that he starts off his decision by
saying what he
stating that
thinks
he's
the
applied the Giannis standard and distinguished it here. And then if you look at each and every finding.
Can I just interrupt you? Dicta is not when the judge says, this is the standard I'm applying.
No,
Dicta
and
is
when
the-
he said the standard he was applying, he said he was applying Giannis. And if we look at the decision, forget about his statement right there, and you actually
How
look at
can we
each one of the
forget about
decisions.
his statement? How can we forget about his statement? It's
Because
not-
his decision isn't premised on that statement. He's actually asking for guidance and stating to the appeals court, and I think it was a favor to us as practitioners because this is an area of grayness, this is an area of confusion, that he's stating, look, I believe Giannis has evolved. The offspring cases of Giannis has put the focus where the best interest of the child is not at the crux of the inquiry, but rather that the crux of the inquiry is the improvement to the mother, or the custodial parent, flowing to the child or to the children. And I think that he has expressed that as a concern. But what's most important is that we have findings. We have page after page of his
Ms.
findings that
Minchoff,
fit.
could I ask you a different question?
Yes.
These are tragic situations for parents, because it seems to me that one of the things that Janos does is to say, first of all, we want to make sure that this, you've got conflict between the parents, both of whom love their children, and we want to make sure that somebody is not moving out of state in order to take the child away, right? So that's settled in this case. Clear findings, that wasn't. Then it seemed to me, and I'm looking at Judge Kanclewitz's decision, that the factual findings that he makes about Jared would be the case in every case unless a child was desperately unhappy. In other words, children are where they are. So he's well adjusted in the current setting. Yes, children, if they are well adjusted, are in the current setting. He's got a close relationship with his sister. Yes, if you are in the same neighborhood. Has a close relationship with his father. Nobody is claiming that this was a bad father, quite the contrary. He had an extensive social circle of friends and family. Yes, because that's where you have your friends and family. In other words, Arizona is new, different, and other, and that's the tension here. Because unless there's a parent who's not carrying out custodial obligations, has a bad relationship with the child, which nobody is claiming either parent does here, essentially that's going to be the case in every situation, isn't it?
No, Your Honor, I would disagree, because you look at many cases where you're finding that the move to the custodial parent, the benefit to the move to the custodial parent, and when you're looking at the flow of that benefit, how it's going to trickle down, you're seeing that there's going to be a sufficient or significant increase in financial stability. You're seeing that they're going to a social network where that child is going to be able to benefit from that social network.
Sometimes yes, but not always.
But those are the real advantages that trickle down. And in this case, this is more like the Dickinson case in that we don't have any trickle-down effect other than the fact that mom's going to be happier following her fiancé to a place with a better environment as far as weather and certain other exterior factors. And I would just end by saying that this case, I do believe, and I believe it was Justice Cordy that mentioned it, is more online to Mason, because when you look at the parenting arrangement between these two people, you are looking at a man who has been very involved, and I don't think that you can say that Miss Abbott alone has established a lifestyle that this child is accustomed to. It is both parents doing that. Thank you, Your Honor.
Thank you, Ms. Minchoff.